come to page paragraph 197 of common cause.
Yes.
So yesterday you made a suggestion that those in the vegetative condition,
PVS.
previous, should also be part of, should
Yes.
be treated, I mean, should be getting the benefit of this advance,
Yes.
what do you call that? Whatever you call it.
Advance Directive.
No, just read this para 197. Because in the context of Townbound,
Yes. Having dealt with principles in vogue across the globe.
just a moment.
Sorry, sir. My apologies. Lordship may take page 129 of the SEC volume.
That's
May I start?
yes.
Yes. Honourable Lordship. Having dealt with principles in vogue across the globe, we may presently proceed to deal with the issue of advanced medical directives, which should be ideal in our country. Be it noted, though the learned counsel for the petitioner used the word living will, yet we do not intend to use the said terminology. First, we have already stated that safeguards and guidelines are required to be provided. First, we shall analyze the issue of legal permissibility of the advanced medical directive. In other jurisdictions, the concepts of living will and involvement of attorney are stipulated. There is no legal framework in our country as regards the advanced medical directive, but we are obliged to protect the rights of citizens as enshrined in Article 21 of the Constitution. It is our constitutional obligation. As noted earlier.
Yeah, it is here that we wanted you to. This sentence, please read.
Yes. Next sentence.
Yeah.
As noticed earlier, the two-judge bench in Aruna Shanbag has provided for approaching the High Court under Article 226. The directions and guidelines given in this judgment would be comprehensive and would also cover the situation dealt with in Aruna Shanbag. The reason is that Aruna Shanbag said go to the High Court.
That's right. That's right. That is when Aruna was alive. Somebody took up the key. I think
She's 28 years. She was 28 years.
37 years. 37 years. So what you're saying is this last sentence actually gave us the impression that the directions and guidelines to be given in the judgment would be comprehensive and would also cover the situation dealt with in Aruna Shanbag.
Yes.
So what we want to find out from you is, supposing somebody is in a vegetative condition and in his advance, he says, if I go into an advanced vegetative condition, then also, it should be
Nice report should be withdrawn.
Whether this sentence was what the court intended, but when it came to actually articulating it,
yes,
in 198.4.1, it refers to even to the executor becoming terminally ill.
Yes.
And is undergoing prolonged medical treatment with no hope of recovery and cure, then etc. etc. So will it impliedly cover vegetative condition also?
Yes, and
it was intended, but then
because lots.
But then the doctor says no.
Page 475. Page 475.
And very little incongruous, because actually in Aruna, all that the doctor said has been reflected. What is the condition of somebody in a vegetative condition where she's smiling, she's responding, and then only in the form of a very brief smile. And therefore it was found that no, we will not allow it to be withdrawn. The petition was actually dismissed.
Correct, but they approached the High Court.
And that's what I'm saying. No, finally it was dismissed.
Correct.
No. It was, in that case it was withdrawn. So how does it gel actually? I mean,
Yes.
how do you?
Yes. No, my lord, as far as
Just see that, Sanju's judgment, you have to just refer to that.
I'll refer to that. Can I take a lordship's permission to refer to para 475 of the concurring judgment, because that will show that this was also argued.
Right.
Yes, lordship will just come to page.
And one last thing before we found also, first of all, this is not a petition styled as one for modification even. This is styled as one for clarification. Number one. We found, secondly, the counter affidavit of the state union is one which puts up at least appearance of a stiff opposition. It says it should be dismissed. that's the, you have come around to some kind of a reapproach between you both. I mean, it's a different story altogether because we don't know how it happened. But in the counter, the pleading is, which we would necessarily have to refer to, that this is actually only
Adversarial.
no, adversarial, and it cannot be all safeguards with this.
Just to fill up the vacuum is concerned, absolutely we are for that to simplify the procedure within the this one.
We are just telling you because
Yes, yes, no.
readings also.
I missed that counter part of it.
We went to the counter
Because, sorry, I'm sorry.
we saw the counter so that we have to say that in departure from the pleading, a different stand is being taken by the union to the extent that they are agreeing with you.
Yes, yes. Lord, I'll tell you what happened. We moved the application for clarification because this judgment came in March 2018 or 19, 18. 18. Then subsequently, when this was there, then we found that people who went to apply for advance directives could not do so. The judicial magistrate would not take. So there were a lot of hurdles in that. Then, as I said, then when many doctors met me, met her also in Madras, I also spoke to some doctors in Bombay from leading hospitals. They said this kind of a review board will not work, collector will not work, etc. is unworkable. Now, what is the remedy? So at that time, there's a constitution bench presided over Justice Sharun Mishra. So we mentioned to the bench and said that, look, this is the problem. We are going to move this application. His Lordship heard us for a short while and said, and then we also said these are practical problems. Then they issued notice. That's how the matter took off. And then it was heard once. Again, we point out the practicality. They said post for hearing, etc. That hearing. Now, when the matter came before
we filed the review, it would have gone in circulation.
Yes.
You know what happens?
Yes.
It will go into the judges who heard it.
Yes. Yes.
So
It will be a terminal case in a lighter way.
the many possibilities would have been there. They could have put it for oral. I mean,
No, but the Lordship is right. One option was to file a review.
it had been done, and it had been mentioned. Probably they would have put it for oral hearing before the same judges who had the opportunity of discussing it right there, as my brother said.
No, actually, what happened was by the time this came just before in March, April. True. But other reason the review may not have been filed is that we thought that this is basically not an error of law. We are not questioning the judgment in that sense. We are only questioning the direction which were issued, which
That's
with all good intention.
That is the nub of the matter. The ultimate the analysis. What is it that it's an error in the order?
Yes.
That's a review.
Lord, we can also, if the Lordship wants to revisit it, we can file a review also. That's not an issue. We can do that. But we moved the application for direction.
We have spent as my brother.
Yes. No, we'll move the application. But in case they want to file a review, we'll see later.
Assuming this character of a suit in perpetuity, what we call continuing mandamus, and their directives are.
Yes. No, but what happened was, I discussed.
But this is not like that.
No, actually what happened, we had not suggested any draft guideline. We only wanted to accept that the advance directive is legally valid in our constitution, though there is no statutory framework. An advance medical directive must be given legal sanctity. And that was accepted by the court. And Lord, in the law, now just take page 475, page 251 of the judgment, since the Lordship referred to page 197. Kindly come to page 251.
Yeah.
Yes. Now, please see page 472, first two lines, 473, two lines, then 475. Advanced directives, page 472. Advanced directives have evolved conceptually to deal with cases where a patient who subsequently faces a loss of mental faculty beside has left instructions when he or she was possessed of decision-making capacity on how future medical decisions should be made.
Page 250.
Sorry, 250, my apologies. Paragraph 472. The concurring date. I'm so sorry.
Yes.
But if your Lordship sees the book, it may be better, Marwan. Some confusion in the paragraph number.
It's online.
That's the problem. We'll go by the book.
That's it.
The photocopy of the judgment is.
It is SEC online. So
If it's a true copy, then there is no problem.
it is SEC online. The paragraph is not adding the data.
Paragraph 47.
472, 473. And just two lines and then I'll come.
Yeah.
Or Justice Bose's page numbers are same, no?
Yes, 251.
250, can I take a lot to 250 first for 2 lines? Advance directives, para 472. Para 4, advance directives are evolved conceptually to deal with cases where a patient who subsequently faces a loss of mental faculty to decide and left instructions when he or she was possessed of decision-making capacity on how future medical decisions should be made in Stanford and Side. Please go to page 473. The principles of patient autonomy and consent are the foundation of advanced medical directives. A competing and consenting adult is entitled to refuse medical treatment. By the same postulate, a decision by a competent adult will be valid in respect of medical treatment in future. And that's called subject standard, that when he was conscious, he didn't want treatment. Therefore, when he's unconscious, his respect should be restricted. Now, please come to 474, which talks of permanent vegetative state or permanent persistently unconscious condition. Lordship has got 474, para 474. Advanced directives are thus documents a person completes while still in possession of decisional capacity about how treatment decisions should be made in the event he or she loses decision-making capacity in future. They cover 3 conditions: terminal condition, persistently unconscious condition, and an end-stage condition. Terminal condition is an incurable or irreversible condition which, even with the administration of life-sustaining treatment, will result in death in the foreseeable future. A persistently unconscious condition is an irreversible condition in which thought and awareness of self and environment are absent. An end-stage condition is a condition caused by injury, disease, or illness which results in severe and permanent deterioration indicated by incapacity and complete physical dependency, for which treatment of the irreversible condition would be medically ineffective. So these are the 3 things.
But
So,
that is the doctor said yesterday, this persistently unconscious condition, you cannot say, because after some 12 or 13 or 20 years, somebody may come back.
yes,
That is what
they agreed. There my answer is, suppose a
so it
person...
cannot be said that it is an irreversible condition. That is what.
No.
One point. In the Aniruddha Bose case where she was in persistent vegetative state, there were medical criteria for the diagnosis. And this diagnosis was made by a panel of doctors.
The brain stem was working.
No, brainstem was working, but this was a vegetative state. There is permanent state of unawareness. So there are medical criteria. You cannot say that somebody will
In the case of Shanbag, her brain stem, you see that 2011 4 SEC judgment, where the court has drawn the diagram also, then found the upper brain, the whole thing dies, then you can signify it as death.
So, but not brain damage. This is
She was not on mechanical support, life support. She was breathing on her own.
Is the analysis. Analysis
Very good.
there in the video.
Just see the judgment.
It's in paragraph 45 of this judgment.
It is analyzed for legislations.
there are 2 distinct conditions: brain death, which is brain stem death, and BVS, which is a permanent state of unawareness. And that is diagnosed through medical criteria. So that was that procedure was gone through in the Aniruddha Bose case. So she was in a PVS by medical criteria. And she had not woken up after.
Just see 2011 4 SEC.
Yeah.
It's important that you see it because this is a backdrop in which the whole case, it's the 3 judges
Yes.
then doubted it and then went there.
What 2004 is? Then a combined-
Come to page 516.
No, I just don't have that book. I'll just get it from the library. But just while I get the book, to answer my lord Justice Ravikumar's question that PVS and what doctor said, can we not have a situation where, as part of the advance directive, my own advance directive, so the patient's advance directive, he says that, look, should I go into a permanent vegetative condition, which is medically defined, then the possibility that I may get after 10 years or 12 years, I don't want to be lying in bed for 10 years. So let me go peacefully. Is that not open to me? Because now you say if I can, when I'm mentally conscious, if I can refuse medical treatment, I know that I got some illness. With medicine, I can live for 7 years. But the medicine is so horrible. I don't want to take, I'd rather go away. So I'm just Sorry, Baba.
Kindly come to page 515 of the SEC. 515.
Yes.
It's replete with a diagram
Yes, yes.
and this schedule judgment. Please read brain dead, under brain dead the discussion.
Para 112, no?
515, 112. Please read that.
Yes. Brain death. All lordships have got it. All your lordships have got it.
This is Roy.
Yeah.
Brain death may thus be defined as the irreversible cessation of all functions of the entire brain, including brain stem. It is important to understand that this definition goes beyond acknowledging consciousness. A person who is incapable of ever regaining consciousness will not be considered to be brain dead as long as parts of the brain, for example, brainstem, that regulates involuntary activity such as response to light, respiration, heartbeat, will continue to function. Likewise, consciousness, albeit severely limited, is present, then a person will be considered to be alive even if he has suffered brainstem death, wherein breathing and heartbeat can no longer be regulated and must be mechanically determined. Hence, the international standard for brain death is usually considered to include whole brain death, that is, a situation where the higher brain, the part of the brain that regulates consciousness and thought, the cerebellum or the midbrain and the brainstem have all ceased to demonstrate any electrical activity whatsoever for a significant amount of time. To say, in most cases, that only the death of the higher brain would criteria for brain death may have certain serious consequences. For example, a fetus technically under definition would not be considered alive at all. Similarly, as per this, different definitions of death apply to human and non-human organism. For the facility of readers, discuss in the judgment if recruiters below. Then
Now you come to page 518, paragraph 121.
yes.
Morning.
From the above angle, it cannot be said that Aruna Shambal is dead. Even from the report of the committee of doctors which we have quoted above, it appears that she has some brain activity, though very little. She recognizes that persons around her are around her and expresses her likes and dislikes by making some vocal sound and waving her hand by certain movements. She smiles if she receives her favorite food, fish and chicken soup. She breathes normally and does not require a heart-lung machine or intravenous tube for feeding. Her pulse rate and respiratory rate and blood pressure are normal. She is able to blink well and could see her doctors who examined her. When an attempt is made to feed her through mouth, she accepted a spoonful of water, some sugar and mashed banana. She also licked the sugar and banana paste sticking on her upper lips and swallowed it. She would get disturbed when many people entered the room, but she appeared to be calmed down when she was touched or caressed gently. Aruna Shanbag meets most of the criteria for being in a permanent, persistent vegetative state, which has resulted for 37 years. However, dementia has now progressed and has remained stable for many years. From the above examined team of doctors, it cannot be said that Aruna Shanbag is dead. Whatever the condition of her cortex, her brainstem is certainly alive. She does not need a heart-lung machine. She breathes on her own without the help of a respirator. She digests food, and her body performs other involuntary functions without any help. From the CD, which we had screened in the courtroom on 2/3/2011 in the presence of counsel and others, it appears that she certainly cannot be called dead. She was making some sounds, blinking, eating food put in her mouth, and even licking with her tongue morsels in her mouth. However, there appears to be little possibility of her coming out of PVS, which she is in. In all probability, she will continue to be in the state in which she is till her death. The consequences whether life supports.
Thereafter, the court in paragraphs 124 proceeds to deal with the case of PVS and what
Yes.
remedy
Yes.
permitted.
Now, I am.
A writ petition, parent petri jurisdiction is
Yes.
referred to,
Yes.
and then the
Parents
remedy,
Petri, yes, lots of.
and a team of doctors to examine them. And finally, in the end, the petition was dismissed as far as Shanbag is concerned.
Yes.
Now we pointed out to you paragraph 137 that, that where he said that the guidelines will cover situations governed by Shanbag case. What is the meaning of that?
I'll put it this way. Suppose Aruna
Don't
Shanbag.
understand what is the meaning. Was it to be covered? Was it to be not covered?
No.
As long as life is there, and as doctors say, there's a possibility of your going back. You don't know
No,
what.
here, but Supreme Court has said there is no chance of work. I'm just putting it this way, Lord. The chance
Nebulous
of
area.
No, can I say one thing, Lord? Lordship will just imagine, Lordship asked, what was the court intending when they said it will cover Aruna Shanbag? I'm requesting your Lordship to visualize. Suppose Aruna Shanbag had given an advance directive that should I come in this condition, please don't continue my life support. Now, today she's not on life support, so maybe it's a different situation. But suppose she was in a PVS and required life support, required so much thing. And then the point is two things, withdrawing life support and not providing life support. Here she was living with life support. I mean, she did not require support.
Para 136, in fact, the court discusses about suicide. What is
passive? Assisted dying.
Para 136, you get the
Yes,
whole.
yes.
So, and doctors have been sort of told that it will not amount to suicide, 306, 309.
Physician assisted dying.
Yes.
I don't want treatment that's not diabetic.
In fact, there was a recent gentleman in Australia. He was very aged and he had some kind of a terminal. He wanted to go. So he went to Switzerland and there they can administer lethal injection at your choice. So he said that I want that. It was his choice. There was no hope of his recovery. And they actually administered an injection and he said that he wanted his favorite Fifth Symphony or something to be played in the last moment. There was a big article on that also. It happened. He had to go to Switzerland and do it. I'm only asking.
A refrain which you find very perseveringly persistent in all these judgments is about the conditions obtaining in our country,
Yes.
about the absence of ethics,
Correct.
about a lack of morals, which might drive profit-driven conduct. Beware of it. Court says throughout we were just seeing it. Relatives might be very, very, enamored of the idea that this lady should not go through a particular treatment, not because of that lady, but because you will get to her wealth very quickly. So beware of it. We also should be beware.
No, that is why.
So the safeguards.
That's why the advance directive is done when she's fully conscious, and that's why a Lordship put the safeguard of witnesses and putting before notary public, putting in the national health record. Number one, my only humble submission is the possibility of a misuse, therefore it's a relevant factor, cannot deny the possibility of a person.
That apart, what is your submission? We just wanted to highlight.
Pardon me?
That apart, what is your submission?
My submission is this, Lord. Now everything has been agreed upon. The only hurdle which we are facing is what about the review board? Primary board we all agreed upon. This is Rastogi also suggested. Team doctor, 2 subject, Lordship made it 3
I'll
doctors.
tell you something more. And now that it strikes us. See, Government of India, please listen. See, you should realize one thing. Areas which are meant for the legislature to exercise its power.
Yes.
By not exercising the power.
Yes.
And by actually sort of agreeing to all these things being issued by the court, you are actually passing the buck. And you are actually, okay, ultimately you will say, see, we didn't do anything. Actually, court ordered it. You are abdicating your legislative, we can't be telling you the legislature is a body. But then finally, under the, scheme of separation of powers we have, this is squarely a matter which you should have taken up.
But it was,
We're just telling you.
yes,
So
yes,
that-
I understand. But it was deliberated upon.
How it to, what we do or what we not do is not the important thing. This is a matter where the chosen representative will debate and find
You debate it
very meticulously detailed. I think which will have greater amount of wisdom. Thing which we don't have. We don't have the expertise except what you are providing us.
In fact, the guidelines framed by this court, nobody had given the frame. Court framed the guidelines on after consulting after seeing the submission. It was not put the draft guidelines to the medical.
The whole idea of
No, if this court had given these draft guidelines and given it to the medical community, they could have got a feedback at that time itself. It came straight away as a part of the judgment.
that's
Actually,
In short, my submission is this.
the issue was,
Suppose
let me-
Avinash-
one second,
I'm sorry.
the issue was actually deliberated upon. We have filed an affidavit to that effect, and the original writ petition that may clearly be looked into. It was deliberated upon, it was referred to 3-4 times to the expert bodies, the doctors, then thereafter finally the government has taken a conscious decision, we need not go for any
you
legislation.
did not, you know that.
Yes, that is a categorical stand we have taken in the original writ petition. It is not required, or should not be done. Because it, for various reasons also have been given, I think if possible, can you
So do
look
you agree with the original directions or are you agreed by it?
we are not agreed with the original directions.
So you are accepting it?
But we have accepted it as it is. It is now he is seeking certain this one clarifications.
So what is?
Please.
get the drift of my question. My
Please.
question was,
Please.
if you think a law is not needed,
Yes.
but the court makes a direction which have the garb of a law
Legis-
under Article 142,
Yes.
it's binding.
Yes, binding.
You have not filed a review.
Yes.
You have accepted it.
Absolutely.
But I'm quite, because we had multiple meetings after meetings after meetings, and we both agreed that
That's right.
these guidelines are not
Okay, so what
workable.
is your next point, so that, we can go to that.
Yes.
What else he wants?
Whatever that you provided to us in this miscellaneous application. Have you consulted the government?
Yes, we had multiple meetings.
Multiple meetings have held.
That's we are.
Yes.
You also
Yes, we had a meeting.
suggest us.
Yes, that's what now yesterday we suggested about various things. Now only about the now the.
The entire concept of primary board report came after discussing with the DGHS, AIMS director, health secretary.
You put up a joint kind of thing.
We had multiple meetings.
No, I'm telling about you and the government.
Yes,
If you could put up a joint proposal
yes.
for altering it.
That would be.
That would be the best way, because in which case, it makes not only makes our task easier, there will be clarity.
Yes.
Then we can chip it with whatever.
Absolutely, absolutely.
Mr.
But I just,
Mr. Datar, the difficulty that the court is facing the difficulty.
sorry, ma'am, yes.
You see, a particular stand is taken
Yes.
in the affidavit that has been filed.
Yes.
And although there have been very many discussions, that is not forthcoming as a common document, authenticated by the government.
No, this is the steps which we both agreed upon based on discussion. The
No.
primary board and review board.
Should it not come across together?
I think
No,
it
no,
would
no.
it would be better if a comprehensive proposal comes
No,
from
that is
both of us
possible.
together.
Exactly.
We are not, it should not be taken as an adversarial thing. In fact, we are very much with you in the manner that you are projecting and the difficulty that you're projecting. So you also must not think that, but only thing is that once in a while, there are reactions coming on the basis of instruction received across. We are noticing that.
Yeah.
Of course, Mr. Natarajan is also perhaps bound by the instruction that he receives.
Yeah.
So that is why the difficulties are happening.
Yeah.
We are getting a bit of a contrary kind of signals.
I agree.
See, your stand at the, before the constitutional bench,
Yes.
is from paragraph 10.
Yes.
Paragraph 10, what was stated in the constitution, it was that conjunctive.
Yes.
You said that, it was elaborately considered, but then you are not in favor of enactment due to the reasons. You have
Correct.
given the reasons.
Correct, we said so. I'm grateful.
Mr. Natarajan,
Please.
he must be having this,
Yes, I have this one.
suggest us with the government that
Yes,
all right, these can be workable, these are not workable
Put
to
it
us.
as joint.
And what is not workable, what could be,
I can
to
do
make it workable?
I can do.
Ultimately, that Mr. Datar is not interested that, no, nothing doing what he says final.
Yes.
He only wants the things to make workable
Yes.
and people should get the fruits out of it.
Yes,
Otherwise, the 1,000-page judgment is not only for the papers to be placed.
that's right.
That people must get benefit of the final verdict being given by the court.
Yes,
To be implementable now.
That's the most important. Obviously,
I understand.
otherwise, full volume has been consumed.
I can prepare this specific comments on each of.
Over the weekend, then just prepare this.
In fact, what
Hand
happened
over to
was,
us.
yes, in fact, what
We
happened
can
was,
do it by Monday.
Very well.
Also read it in cup and dictate order.
Very well,
No reserving, nothing.
very well.
no, I'll tell you what happened is,
No, what is, if this might be, actually, it'll iron out many a three.
yes, no, I'm just saying, the right of my friend said, what happened was, an order dated 22/1/2020 is passed by a 5-judge bench. Arun Mishra, Indira Banerjee, Vineet Saran, M.R. Shah, Bhatt JJ. Let response be filed within 10 days. It is submitted by Learned Council that they are trying to convene a joint meeting of all the stakeholders. Let there be a joint meeting in the meantime and consensus if any place before the court. The case is adjourned.
So that consensus has not been placed before the court so far.
That's the step 1 to 6 of the consensus.
Still, it doesn't, there they are having objections, for example, they are having objections to vegetable consumption. They have raised objections before them. So
No,
it
no,
can't
no.
be a joint. But what you're saying is something different. if both of you can, once you agree on what is the irreducible minimum, as it were, on which you are actually coming to an agreement, and it is in writing, it will be easy for us to either accept it straight away, or with such modifications coming with themselves to us, dictate the order. Why create any kind of, because see, we are
I
here.
get the point. Instead of we deliberating this, the line, that line, why cut it?
Why?
And then it's your lordship to say, no, we don't agree, we agree.
Yeah, because ultimately the most important stakeholder is who? The government. Because it should be the body. What in the sense that it is the body, normally it is the government which will move the bill, which will become law. And that's how it should have been done. But here, government in its executive capacity is before us. And to the extent that they can help us resolve the problem, we'll take inputs from them. So here we'll have clarity, because what will happen is one word not here, one word missing, one word added extra. You will come again next time with another clarification.
Again, 5 judges.
So why file do this?
What I'll do is, I'll,
This weekend, over this weekend,
Yes.
if you sit together,
Yes.
both of you,
Yes.
and file it by Monday.
Yes.
But can I suggest one thing? Can I suggest one thing? I've given my corrections in red because this, so whatever they don't accept, let them say so, then finish it off. Because Marathi Lordship, why not? Or after yesterday, after 5:30, again, I talked to a number of people. Just 2 points I'll mention and I won't take. Now, we are all agreed 2 things. We are agreed that the direction as existing will not work. We are all agreed joint mindset should not be there. Agreed. We are all agreed that, look, it should not be just an advance directive because of the Indian condition. Somebody may take advantage of it and say, oh, this advance directive, finish it off. Therefore, they say, no. Despite advance directive, let it go to a primary board. Then the Ministry of Health suggested, look, instead of having a primary board, you're taking away somebody's life, let it be subject to a further second tier review. Many doctors I spoke to, they said, you have to trust us. Where's the question of review board? Other important feedback we just put on our affidavit, and I spoke to some leading surgeons. They said, look, the statistics show that from the time a person is very often terminal, it's a matter of days before you're withdrawing life support. We're not talking about if it's a terminally ill cancer patient and he's living normally, then he fills that AIM form and says that ultimately if the time comes, don't have this inappropriate treatment with that form says so. We are now talking of a case where a person has gone into a coma, he's on ventilator. Now, what doctors told me is just be practical. Is it a time where the primary board, a secondary review board, go to the collector, put it there? So they are saying that, look, it won't work. So we are talking of, and every day of intensive care is costing a fortune unless he's in a government hospital. So when I said primary board and review board, what I was saying was if a person has gone into a coma, like an accident, he is brain dead, but he's on ventilator support, he has to be kept breathing alive. So they say that, look, and the statistics show that we made how many, out of 1,000 odd cases. Yes. Just show the. Medical Hospital. There are 474 cases where such decision had to be taken per year in 1 year. Then we have got cases where they examined 2,000 cases all over India, and they said that in more than some 70 odd cases, the time between this happened and the end of the life was hardly 8 days. So that's why this primary board, review board becomes impractical. Then all our exercises are reduced to futility. So as long as there's advance directive and there's a safeguard.
Subtle, I have an aspect which struck us. The case of Schoenbach, she was in a vegetable condition. Why? And now we able to pronounce.
The attempted rape and somebody hit her with a chain and all that.
No. Her condition, vegetative condition, 37 years. Correct? The court dismissed her petition. But then court also said, you can file a writ petition. What is the meaning of it?
No, because they say the High Court judge is the parent patriarch jurisdiction.
No. What you're saying in the case of
my friend can shoot
in the case of Schoenbach, it was dismissed by this court.
Yes.
Because they didn't agree that Pinky Irani, the petitioner who had filed it, was the next friend of Avinash Schoenbach. They took into account the wishes of the nurses and the caregivers of Avinash Schoenbach at KM Hospital.
She should be
They
kept
wished
alive.
that she should be kept alive, therefore they dismissed them.
That's right.
It's actually a book
It's a
on
pro-life
Pinky
approach.
Irani.
Basically, it's a pro-life approach.
In fact,
all
Mr. Datar, I'm just having here, you can just look at, ask one of your colleague, Lushin Dube's Aruna story. This was enacted this Saturday. Lushin Dube is one of the most celebrated actress in India. So this Aruna story, eventually the nurses, they all said that we'll take care of her. Don't allow her to die.
Because she was a nurse.
She was a nurse, she was raped in the...
Yeah, and then with the personal chain, yeah.
So Aruna's story, just last, I think Kamani Auditorium or something, Lushin Dube. She's one of the most celebrated actress, Lilith Dube's sister.
No, but I'll tell you what's it now. At the end of the day, the only problem.
Let them know about your theatrical.
But we can hear it now. We have heard it now.
So theatre person has got
No,
so much of knowledge of theatre, himself a director, actor.
No.
Many people do not know that. I mean, it brings to impact even some of the judgments I find literary, I mean, gems coming in. From where he gets it from there.
No,
But
but
I was told this is Vivian Bose was interested in magic. He's interested in magic.
Out of the world.
Out of the world.
Out of
And
the
he
world.
drove from India to
No one can come anywhere near it.
But you worked a lot on Palkiwala. He also used to perform magic for children.
initially, yes.
You know, who used to visit him and all.
Yes,
Just to sort of entertain them.
Also very great violinist, very good violinist.
Violinist.
Sorry.
So you can just, we thought that.
No, I will.
So what I suggested, by tomorrow or after tomorrow, I'll convene a separate meeting where I will request my friend also to be present and with on Zoom, whatever the platform is required.
You're always.
Yeah,
keen on
always.
Zoom.
I know, he's so busy, has to be in Chennai on.
We had multiple meetings.
Yes.
No, what I'm requesting is.
So that, by Monday, you put it down in writing and give it to
Yes, so that I can place it
I'm
before
taking
the
your lordship now, on the basis of all our meetings and the basis basically on your lordship's feedback. The only, Mr. Nataraj will agree with me, we are all agreed on a primary board. We are all agreed that JM should go. What your lordship has to finally take a call is what about the review board? That's the point. And what is the time limit? So two things are only, Mr.
No,
Nataraj.
something more is required. Something more is, now after review board takes every decision. No, according to them, it need not be, that's end of it. But however, we have a caveat. After review board takes a decision, at least that decision will have to be given to the learned magistrate. It must be preserved. Because there will be future litigations and so many consequences will follow. Some kind of check is required, number one.
To iron that out between.
Yes,
yourself.
and all these issues will sort it out.
In all our
I mean,
meetings,
that is not.
I'm very surprised, I'm with great respect, when all the multiple meetings I had, there was no mention of magistrate, we all agreed magistrate is not practical.
Know how
That is for the procedure.
valuable your time is, we know that.
No, I'm doing sort of, it's a labor of love.
No,
I'm not saying-
we know that you're doing it for work, so that spend a little bit more time, it will help the court also too.
Then can you also put it on Tuesday, on Wednesday instead of, because
Tuesday, when we'll have to sit for a constitution bed.
no.
Tuesday, we are sitting and we can.
Yes, because the other matters are continuing. No? The other that WhatsApp privacy, all that is now.
But WhatsApp, who you are appearing in that?
Yes,
What
the
is,
symbol is there.
I'd like to know
Yes.
what happened actually. Is the government supposed to come with a law and all that?
No, the bill is being finalized.
Bill is being,
What is going to be the standard? We have to hear that? We thought we were.
No,
under-
I don't think that.
Actually, what happened was, one, when the matter was posted in January, when WhatsApp posted it, they said that they should not take an adjournment if a bill is filed.
That's what
Now,
Shyam
what
was
happened,
saying.
yes, now what has happened is now an elaborate bill has been given. So it's up to your lordship to decide whether the bill, we have also made a table, what are the concerns and how the bill has addressed them. Because then it's a legislature, so that your lordship will take whether it should be a court issue or that your lordship may take it because this is.
That's right. We want Joseph Shine, that's another clarification application.
Yes.
There is say what you say, we wanted on the next.
The Tuesday lordship is sitting in any case, no?
We are sitting on Tuesday, so can we put it tentatively on Tuesday?
Yes, post lunch.
So that.
But I'll do one thing, since I'm not there tomorrow, I'll ask my colleague to sit with.
Fine. Move.
there's no, whoever he can
Whoever
deputy.
sits,
And I'll also join in with the
Otherwise,
video.
the whole thing that happened there, you will again have this, we'll say something and then you'll say it's not.
The only thing tomorrow I'm in Bombay High Court, that's why I may be stuck there. So I will also join in the afternoon post lunch.
We'll have it on Tuesday.
Yeah, well, no problem.
So this is what we expect so that we can dictate.
Yes, absolutely.
We better.
But I will also ask Mr. Because Mr. Nataraj is also there, but all the earlier multiple meetings we had, and on the basis, lordship will see this sixth step which we gave is from the ministry. on the primary board, review board. That's on the ministry. Yes. So now what your lordship is saying is, we had a ministry with two people. My lord Joseph said, no, let it be three. Okay, 2, 3 becomes 3. Now, the lordship may also think, my suggestion is, the weekend also.
About the 20-year-old, 20 years.
20 years, and also on the review, because keep in mind, my humble submission is, the time is of the essence. Clock is ticking minute by minute. So if you're going to have a bureaucratic approach of, say, a primary board, a review board, magistrate to confirm, then till that time, the person has to keep on being on hook ventilator. Then what's the point of him saying that if I'm going on ventilator, remove it? What's the use of the advance directive then? If your lordship is going to put a magistrate, then we might as well close the hearing.
No, not magistrate.
Not for the proceedings. Once it is concluded, it must be this one ultimately final. That is our concern. Let us not be anxious to.
Mr. Datar, if you rightly understood him, he doesn't want that he should intervene.
Yes.
After the board take a final decision,
Correct.
that opinion expressed by the board either way has to go to some magistrate.
Yes.
You can convert from magistrate to executive magistrate. You send the paper there.
Yes.
That executive magistrate
Yes, some kind of-
has to intervene.
No, what I'm saying is,
Ultimately, the opinion of the doctors is final.
no, I'm saying.
The fellow has no role to
Yes,
play.
I appreciate it. I'm asking myself the question. If a primary board, a review board has confirmed that Mr. X is terminally ill, please don't put ventilator. What are we discussing? That day-to-day life support need not be given. It's behind life support.
There we can chip in with something which might help. We can think of some timeline.
Yes.
You have to actually say.
We'll discuss on that. We'll discuss and give.
That you can say and we'll incorporate.
And what we can
That
do-
will be the best safeguard.
Yes, and humble request that my friend also can consider. Let the decision has been recorded. The reasons are given for withdrawing the life support in terms. That is a hospital file. Now,
No.
if it is going to be in question under article, the record is there. Now, by giving it to a magistrate or a secretary or a ministry, how does it make a
What he
difference?
intended was.
Or can I say this one thing? Sorry.
You have perhaps not understood what he.
Yes, yes.
What he's saying is that once the decision is taken by the review board, for example, that it should be communicated for it being kept as a record.
In part of the medical record,
Not for the
digital record.
purpose. He's not going to sit in judgment over.
Correct.
No, then why can't it go to the national digital medical record itself?
Let it be with the official body.
Yes.
No, that's a government body.
No.
That's right. No.
Let us not be anxious.
You find, you got
Let-
that out.
I'm-
The National Digital Health Mission, which has got its records,
That's how you can hide that out. We have no problem whether it goes to science stage or whether it goes to this man or that man, whichever man.
No, Mr. Natarajan,
Yes.
National Digital Health Mission.
Yes.
You take instructions because you see that's already there.
Yes.
Whether you want to bring in a third party, meaning there were third party as we are talking about, not
Yes.
otherwise strangers,
Yes.
magistrate, collector. What I'm saying is you have a digital health mission portal already.
Right.
So if you keep it there,
Yes.
it is protected. So obtain your instruction.
I'll get instruction.
Let it come as a joint kind of a thing, not come from your side.
Yes.
Because at that point of time, instead of 2, 3, we are debating this.
Yes.
And that's actually derailing the smooth flow.
Correct. That's right. I'll get it. I'll try to.
Already put 8 years.
It would be practically impossible.
Impossible. Correct.
In many places.
Correct.
It is not a simple thing to have and such an experienced doctor to have him over on a medical board.
That's right. That's not possible.
Somebody is taking care of critical care
Correct.
patients.
Correct.
Ask him that please come and attend to
Correct.
this.
Practical. Practical is a practice.
So these are, he'll have to give up on treatment that he's rendering to somebody
Yes.
and then come and
Yes.
participate.
I agree on that. And we are also on that same, this one on the same page.
I don't think if you speak with Mr. Datar and Mr. Natarajan, perhaps you will be on the same page.
Same page.
Only thing it should be forthcoming
Yes.
as a common kind of a document.
Only thing we have some kind of difference only on some of the issues, like there must be a proper check. That we should not be anxious to take away somebody's life, whereas our concern is to protect somebody.
Nobody
Yes.
would like to.
Yes.
There's a contrary we are discussing. Let me not take part in that discussion.
Yes.
I have something called whose life is it anyway?
yes.
There somebody was saying that let me die.
Yes.
And the hospital attendant said, why should you die? The patient who is totally confined to bed, he said, what life, what use of life do I have? And then the hospital orderly told him, you can do so many things. What can I do? Well, you can say look at people who are traveling around in your room. Yes. You can umpire a tennis match. And if you are, feeling a little this thing, even table tennis, umpire of a table tennis, referee of a table tennis match. So, I mean, that was an argument, counter argument. In whose life is it anyway? Very celebrated play of production of UK, where the patient was being persuaded not to end his life.
So you're partly converted Datar.
My brother has bought all literature
But
in there.
right away, suppose it happens to me, I know I can watch the table tennis match or tennis match.
Correct.
No, but since the Lordship said don't quote foreign judgments, I refrain. But if the Lordship sees the UK judgments, what they say is.
We didn't say that. We didn't say don't quote.
No, Lordship said Indian conditional reference, so I refrain from showing that. The general trend of the law is when a man, and that's what Justice Aniruddha says, called a subjective standard test. This man, when he was conscious, he said, I don't want indignity. So when he's unconsciousness, by making these multiple checks, you're suffering, making him suffer indignities.
That
Primary board, secondary
We
board,
are not going to-
magistrate, that man, you're
Let us-
very vicious.
I'm making very, let us
So
not,
what the English
let
court
us
says
not be
is-
anxious to take away somebody's life. There must be proper check.
No,
We are concerned about, we are bound to protect it.
We're not taking anybody's life. We
That's
saying
what
that-
you're in a hurry, you want to take
Court
away.
says that if the advance directive is there, even if somebody else wants to, please respect him. Suppose Aruna Shah had made a medical directive. Suppose Aruna Shamba had made an advance directive. What would we do?
Datar, actually, we are actually, in this whole debate, we are.
We are playing God.
Not playing God. We are belittling so many other values.
Yes.
So many other values,
So what-
that's a larger debate which we.
Correct. You know, what I'm asking is, when you're talking of value,
When you want to, if you're becoming so kind of thing, your understanding of what is suffering, what is life, what is the spirit, what is God, whether you're an atheist, you're agnostic, the whole lot of them. I mean, that's a larger debate. Let's not get there.
you know, Arun Shuri has written a book. He says we prepare for everything, but we never prepare for death. It's a lovely book. It has gone into different areas, and he says, how do you prepare yourself for dying? And I can give a copy to your Lordship also. It's a very book. Only thing, there's a book which you can't give anybody as a gift. I can't give anybody a birthday gift, how to prepare for dying. That's what is the problem. Otherwise,
Is his son's photo on the cover of the book?
no,
His son's photo?
Yes, no, his son is being blessed by Dalai Lama. It was revealed by the Dalai Lama. And his son was completely a vegetable. Actually, he's 6 feet 3 inches, but he can't have cognitive faculties. So he put his hand on the Dalai Lama's head as if to bless. So that's the photograph there. But it's a book for preparing for dying. He says we prepare for so many things, but we never prepare for dying.
I know somebody the parents both are doctors, but unfortunately they got it wrong. Their first child was born with cerebral palsy. Correct? They're in the States. They get the best treatment. So I've seen them, I watched them. So the father says he cries. Whenever they have parties, he goes into a room and he cries. Can't see his daughter. But the daughter is the very the whole joy of their life.
Yeah.
It's about 40 years. Seeing her
Same
from time
thing.
to time. It all depends upon how you look at life.
In fact,
If you are pro-life, you want to think that, that okay, that.
No, these people are like, these people are actually walking, talking. The only thing they have the mind of a 3-year-old or 2-year-old. That's the whole, that's a totally different thing. You're talking of terminally ill patients, where the end is imminent.
That's right.
And in fact, Mr.
Not
Shuri
bad
also,
also.
because perfectly normal child didn't get oxygen in the initial
Anyway,
stage.
my other brother has said about whose life.
No. Since you mentioned Arun Shah, one more book I think all of us should benefit by reading. That is by Dr. Atul Gawande,
Yes.
Being Mortal.
Yes.
That's another very celebrated book. All about how to live your afterlife. Arun Shauri's son you mentioned.
Yes.
It's a personal thing, of course, but perhaps I can share at this moment. Arun Shauri's house I visited while I was riding a motorcycle, a Yazdi motorcycle, which made a lot of noise. I and my friend, we had tea in his house, and then we were coming out. Then my friend, I was just starting my bike. Then Arun Shauri saw that this bike is there. He said, "Can you just wait for a minute?" He went back inside. He brought along his son, the same son you were talking about. He made him sit on the bike while the bike was started. And certain reactions came from the son. And after that, he just said, today I have seen some reaction from my son and you have made my day, my friend, and he went away. This is the experience which I personally had. And that book is currently I'm reading now, Arun Shori's book.
Also the,
I'm sure Datar is going to. Yes.
no, in fact, talking of actual government is apart from checklist manifesto being
Checklist
marked.
manifesto.
You should also see the book, the Emperor of Maladies.
Emperor of Melodies.
I don't know if you're not sure, seen the book Emperor of Maladies
Fantastic book.
by Siddharth Mukherjee. That's also.
He's an oncologist.
Wonderful book.
Here the decision becomes irreversible. Therefore, let us not be in hurry. Let us have a deliberation. Thereafter, we'll
That's
come back.
what we were saying.
Yes.
Datar might still be converted.
Yes.
No, but after speaking to so many doctors, they just require, please trust us. That's all they're saying. And they say time is of the essence. Time is of the essence. We don't have time for these because we're sitting in court. We don't know what happens in an ICU. We don't know what happens in ICC.
Our brother was so seriously putting it forth. And I was doing the judgment. My feeling was that it is in our present system and the busy schedule of individuals, whether we have time to think over about what will be the next. We are so busy in our own schedules. We don't have a time to think. And what should happen to me tomorrow?
Yeah.
In our India, you see, every day in, day out, 7 days, 24/7. We don't have a minute even to think over. When somebody puts on somebody's head, then only strikes to him, what should I do? Otherwise, people are going on. Whether it is a mad race or something else, God knows.
Some life-changing event takes place, then you
Yes.
falls.
You go to funeral, to attend some funeral, everybody mind changes for half an hour. You come outside from the funeral, everything is gone back to the same station. Your mobile also start working and you're talking to some people, please wait for some time. I'm in a funeral, I'm attending funeral, wait for some time. See, the mindset is different.
But if you think actually.
These are the ground realities of life.
It's just like, suppose you are fixing next Olympics, you are saying that it is in 2025, 2025. Tomorrow, one day it is getting reduced, next day it is getting reduced. Same is life.
Yes.
Because every day, one day it is.
In fact, there's a sentence that every.
So if you are thinking like that, you cannot live.
Yeah. Okay.
Because see, after 1 month, virtually 1 month is gone from my life. If you are thinking like that, you cannot live. So is it not better to think how I should live and think about life? Some very few will think about this thing. How I should die, when I should.
Another thought.
No, what people say, you should think about it also. What they're saying is, why do you, Rastogi says, you're so busy with day-to-day
We
preoccupations.
think that we are fully healthy, but still that day is there.
Yes, you should also plan for it.
Excuse me, Nagarajan. Correct. That is what you're saying. You have said that.
Should come jointly.
Come jointly, whatever.
Yes,
That's right.
Come jointly.
That's right.
So just
One
Discussion has happened.
thought which may be.
Joint-
That's right. We'll come back on Tuesday.
One
complete thought.
It's not troubling thoughts. It's how the whole system works. You take a case of a, say, 45, 50-year-old man. Correct? He has been told that, he goes into a sort of stroke or whatever it is. So then he makes advance.
Advance directive.
So he names his guardian. Correct? Then say within 2 years, he actually encounters this problem. The day he gets it, he goes into a coma. Correct? So the court says that any time he can withdraw it. He's free to withdraw it till any time. Now the point of the matter is, it is very relative because it happens all too quickly for him to have a time for revisiting this decision. But this is irrevocable because then, he is not able to communicate that I want to come out of it.
No review.
There is no review. Because the doctor is bound to act.
In fact, the constitution bench just pointed out that you are entitled to modify your advance directive while you're conscious. Yes.
Why they are conscious? What you're saying,
No, actually-
you take the case of somebody that where you want to revoke it, but you don't.
No, my only request. No,
You are
And it's
incapable of.
irrevocable. It's irrevocable.
No, my,
Once you die, once you're gone, you're gone.
No, the point, I thought about this, but I just, what are my thoughts was, as far as the will is concerned, I may have a second look at whom I want to bequeath my property. But as far as an advance directive is concerned, it's a binary. I have taken a conscious decision that if I get terminally ill, then I should not be put on life support and where
No,
the
we
end
know
is.
that.
That's all.
We are already.
So that I may not change my mind. I will not tomorrow say that, look, I made the advance directive. Now I rethink about it, that even if I'm on terminal ill, I want to be tortured and continue. So I'm just saying.
That's the reality is, see,
Life
some
itself is
persons,
torture.
after an unsuccessful attempt to commit suicide, thereafter they are living about
Correct,
25 years. So if they are actually determined to do away with their life, next day also they should, but they will not.
So we'll have, we'll
So
have.
we cannot say that the persons will not change their mind.
Correct it for
It
you
may,
also.
Possible.
it's possible,
Tuesday.
but in this case, they are incapable of doing it, that's all.
It's too late.
Tuesday,
2 o'clock.
2 o'clock.
Oh, yes.
So this we put it in writing and both
Both
of
of
them.
I will, can I also suggest one thing, sir? So because we already given this entire chart to the lordship. Instead of redoing it, what we'll find out is in the remaining, only up to para 190, your lordship has corrected it.
Correct, we have corrected
Yes.
it. But
So-
it's better, if, because they have also, they're there.
He said.
No, what happened was we agreed on that, whatever lordship is,
If you are, we are saying that if you
but
can,
then go from the beginning.
beginning, whatever is agreed, it will be easy for all logistical purpose also.
Yes, yes.
It will remain. It will be part of the record also.
Then give me a real article 142.
Yeah. Tuesday at 2 o'clock.
Will do.
Arbitration, yes.
Please, I'm great.
Arbitration case, yes.